How about it for David Katz, everybody?
Hi.
David, we oftentimes talk about different legal things going on with the Trump family, with the Biden family. We can get to the Hunter Biden thing in a moment. I also want to talk to you about DACA, so we'll try to get through things as quickly as we can. But what lit up controversy for us last hour was something that you've already talked about, and this is video of our David Katz on Fox News Channel talking about this case with this alleged revenge porn for this a woman who wants to be wants to represent a congressional district, right, in Virginia.
Assembly
district. I'm sorry. Thank you. Assembly district. Here's a little bit of David in his most recent appearance on Fox. Tony. Now would be the time to run. David.
And it was on an online platform where anybody can just sign on and watch. And she's thinking she was violated?
Well, Trace, I think as an attorney, no one committed a crime against her. I don't think that this revenge porn works. I think if it were a viable violation of her rights, her attorney would have gone to court and asked for a temporary restraining order to ask for relief. This was put out by the Washington Post. Right. Not by Fox. It was put out by the Washington Post on Monday. She's had 2 or 3 days to go to court and ask for a temporary restraining order. And as your question suggests, she has no expectation of privacy because she disseminated it. It wasn't distributed by someone against her. She and her lawyer husband disseminated, according to all the evidence. They had 5,700 followers, yep. Trace. And on top of that, it was put on publicly available sites.
And you would think, Brian, that she would have given up her right to privacy when she went on that streaming line. I just want to put this up. This is from the Huffington Post. An attorney for Gibson, Daniel P. Watkins, suggests the publicity amounted to a violation of Virginia law, which you talked about, that makes it illegal to record someone nude or in a state of undress and distribute the recording to third parties without their knowledge. But nobody did this. This was not some surreptitious thing, Brian. She did it to herself. She put the camera up.
Okay. All right, you can stop it right there. David, it is super controversial, and you bring up such an interesting point. And by the way, dissemination, I wouldn't have used that word, but I'll give it a ding. I can use twice. Give us just your thoughts on this and the reality of how the video came out. That seems to be critical. Like, if the video was leaked to a media organization, would that change things? Like, from where that video came, is that important to whether or not there was an illegality?
First, I want to say that you may not agree with his politics or, of course, Fox's politics, but Trace Gallagher is a true talent, and it's a delight, to be with him. I've been on his show several times, and we stay off the, Trump, Biden axis, and we talk about criminal cases. And I thought this was an interesting one. And to answer your question, Mark, I just don't think there's any there that a sex crime was committed against her. She's gone really on the offensive. If you want to give him and her credit, she's really learned from Trump, right? That when they accuse you of something, you just put on the best offense that you can. She has an attorney husband. And she and her husband, apparently, she's a nurse, he's an attorney. They apparently had this side hustle, and I don't have any problem with what people do as a side hustle, which was that they would have sex on this thing called Chatterbait. And then they had about 5,700 followers, Mark, fewer than you. But they had 5,700 followers on there. And it was basically publicly available. Anybody who paid $20 or whatever it was could see her and her husband performing these sex acts. So I do think it's rather rich to say that this falls under the misdemeanor law in Virginia about revenge porn, because it's true that if you put a photo out there or a video out there that shows somebody nude with the purpose of intimidating, harassing, or coercing them. But the two problems with that is that nobody put that out except her. She and her husband posed for those videos that they made, and they sent.
Well, they put it out for people who had paid $20. They didn't put it out for all the world to see.
Well, if you paid $20, you could see it. And the idea that you can see it, but that you can't record it, it just as a criminal violation, or even as, like I said, if your lawyer thought he had a point there, he put out this press release with a lot of bravado. As I say, it kind of reminded me a little bit of Trump. But, and then Trump, of course, avoids court. He avoids actually getting a ruling. He just tells millions of people that he's right. If she really thought that she was right, her attorney could have gone to court, gotten a temporary restraining order after this story appeared in the Washington Post on Monday, and said, hey, my rights are being violated. This is a violation of this misdemeanor statute here. Here's the facts. And Judge, I want you to enjoin any further, I know you don't like the word, but dissemination or distribution of what's already been distributed to 5,700 people. And I also made the point, which I agree strongly, you know, Senator Al Franken stepped down. The female Democratic senators hounded him out of office, insisted that what he had done there, which I thought was ambiguous, don't everybody scream, but I thought it was very ambiguous because he wasn't even a politician yet. And what he was doing was a joke. He wasn't really touching, I thought, anyone inappropriately. It was
a joke actually about sexual harassment. Exactly. Yeah.
They hounded him. The female Democratic senators and many other Democratic senators said, we Democrats cannot stand if this man is still a part of our legislative body. And then Katie Hill, you remember her from the upper San Fernando Valley, she resigned, again, for the good of the party. And I think that this candidate should do what's for the good of the party. Let her run in a couple of years. You know, let her run for office in a couple of years. It does matter that this is pretty recent conduct, I think, to a lot of voters, and not something that's 5 years in her past. So let her run at that point. But right now, the Virginia Assembly is really up for grabs. This is a 50-50 seat. It could go either way. And with the Virginia Assembly goes the fate of women's right to choose. So here's a female candidate stumping on the issue of a woman's right to choose. Help women have a right to choose in Virginia. Stand aside for the good of the party. She spent over $300,000, this nurse practitioner and her attorney husband, fighting the primary to get this seat. There was a very competent, apparently, second candidate who she just barely beat out for the nomination. Let him stand in her place this time around. Save the seat for the Democrats. Save the seat for women's right to choose in Virginia.
She made that $300,000 $20 at a time, everybody. That's not easy.
Now.
Okay. But you make a really, I'm so glad we're having this conversation, interesting point that's kind of 2 points, which is no legal case, really, which is what she's pursuing in your judgment, and also the political angle and the political strategy is unfortunately derailed by what she's done. You're not saying what she's done is something, you're not judging what she's done. You're just saying, given the political realities of what she's done, she should step down. So that I think that's an interesting way
One
to go
last
at
thing, Mark. It's a suburban Richmond, Virginia district. It's about, I think, 51-49 Republican, but it voted for Biden. So, I mean, this is really, this one could go either way. This one could go either way. Let the other candidate, Democrat, run for the office this time. Let her run for something else in the future. I do think that it's fair for voters to say, is this really common sense? If you have the plan in mind to run for the assembly, does it really make sense to do this? I mean, people are going to judge this side hustle in a way that they're not going to judge other things, you know? And so, you know, you just, right, politics is full of that. And, you know, a lot of people who agree with Trump's policies vote against Trump because they don't think he's a good role model, because they like the message, but they abhor the messenger. And if you're abhorrent to the voters in some way, and it just seems to me a suburban rich, I may be totally wrong. It may be, you know, I'm like a dinosaur and this is all fine. And this is a sense of self-expression. And I saw some of the comments online and people said, what's the big deal? She made love with her husband. But come on, Mark, especially for older voters, make love with your husband all day long, 3 times on Sunday, right? But to send it out to 6,000 people for $20 a pop, some people are going to vote against you based on that, and they're not going to vote on the issues.
Well, I'd say that in this forum, in our chat thus far, and with Kim too, by the way, because Kim was felt very and argued vigorously with me, similarly, that you're right. That she made a judgment and that she can be judged on that judgment. And Kim said, you know, she can be rejected by voters for that judgment. And I think that the majority of people in our chat, to speak frankly, agree with you and Kim. I'm sort of the lone wolf saying, but I'm making sort of a different argument, which is I think it's unfair to judge her this way. Yet your political calculation, to be honest, makes more sense to me, which is sadly, you know, this is the culture. But honestly, Kim, you made this point well, and I of course, push back on it.
You know what's interesting is I kind of said the same thing David Katz said, but I got yelled at, and you didn't yell at him.
I just
saying.
you made the point well. Did you not hear me say that?
Thank you very much.
You see what I'm up against, David? It's like a marriage. It really is. It's absolutely like a marriage with Kim. She doesn't hear. It's just like they don't hear my darlings in my life. They don't hear when I'm paying up a compliment. I said you argued it quite well, is what I said, Kim. My God.
I'll take that.
Who are the male and female act? The guy who went on to be famous smoking the cigar, Burns and Allen.
Exactly.
Burns and Allen. Bring it
Burns
back.
George and Gracie. Yeah.
All right. So now let's look at just the breaking news. Then I want to get to DACA if we can.
Can we talk about DACA first?
Sure. Let's talk about DACA. Yeah, please go ahead.
Okay. I have a story I want to tell. In 1999, I represented a client. Now I'll call him Tony. His name was Tony. I just don't want to mention his last name, although everything he did was honorable in this case. I represented a fellow named Tony, and we happened to be in federal court. He was a deported alien found in the United States and hard to defend against. Had been deported. He wasn't a citizen, and he was back in the United States because his wife owned a house. This is high school sweetheart. His wife owned a house in the San Fernando Valley, and they had 3 kids, one of them an infant. And there he was being prosecuted by the federal government for deported alien found in the United States. So the whole press corps was out there, not for my case, but for a fellow then in 1999 known as the Pot Prince of Bel Air. So this whole gaggle of reporters is there, and they know that's going to be 2 hours. So the judge says, well, let's call this case first. So I told my client's sob story and all the good things about him, that he had this great American dream, which was not being fulfilled because he was being prosecuted. He was a dreamer. I'm not taking all the credit for that expression, the dreamers, that's used in DACA. This reporter follows me out of the courtroom and says, your case is so fascinating. I said, really, it is. That fellow was Bob Brand, who wrote a lot of stories. He wrote a book about the Menendez brothers, and that story's back in the news again. So Bob Brand follows me out and says, you have a really fascinating case. And he writes an article or puts it on TV. And the LA Times got fascinated with telling the story of Tony's American dream. It appeared on the first page. Rand went on to win an Emmy for his coverage of it. And the high point of it, now remember, the dreamers have not been convicted of anything. My fellow had run with the gangs when he was 19, and he had a conviction from back in the days when he was 19. Then he'd been a case worker with gangs, helping the gang members reform and follow his example of having like a really good, productive life. And so the FBI or somebody in the federal government went to him and said, this is great what you're doing. Why don't you wear a wire? Because you'll be the perfect person to inform on all the gangbangers. He wouldn't wear a wire. So they told him, you're really a slow learner. And when he wouldn't do it, they deported him to Mexico. So of course he came back again. And then when they said, you're a really slow learner, we really mean it, this time they prosecuted him. So at that time, the U.S. attorney was Alejandro Mayorkas. Mayorkas, of course, has gone on to be the secretary of DHS, who has the responsibility of this DACA program and is furious, rightly so, I think, about this ruling. So I take a lot of the credit because this Tony's American Dream won an Emmy. It was on the front page. Everybody was talking about the dreamers. And the good thing was, I think it had an impact on Mayorkas when he was still the U.S. attorney back in the year 2000. When Obama comes in there, Obama actually passes DACA, which is deferred action. And one of the issues in the case, it's sort of a little bit like the student debt. Can the president say, you know what, I'm not going to collect these student debts? Can the president say, look, these people I don't want to deport. I'm the head of the executive branch. Can I tell the INS not to deport these people? And basically, Obama said, let's take deferred action on these people. They were like Tony, but even better than Tony. They were not only dreamers, but they had no record whatsoever, ever. And you look at the lives that these people had. Most of them were English speaking because they'd come here so young. They'd gone to schools in America. Some of them couldn't even function in the countries that they would be deported back to because they wouldn't even know the language.
Not to interrupt, but just to make the point that percentages, if you look at the DACA kids who are grown, the percentages of education and jobs, and it's insane. It outpaces all the percentages for people who are natural citizens who are born and who are American citizens. So yes, the DACA pool is outstanding from the standpoint of who they are as individuals.
There's 600,000 of them by now, and a lot of states like California have really ordered the disregarding of their immigration status. So they've become attorneys, accountants, doctors, other medical professionals. They've made this enormous contribution to society. And the irony of DACA is it is the most popular liberal idea with the conservatives. The reality is that even the conservatives, the Republicans, get it, that these are exactly the kind of people as a group overwhelmingly that we want in America. And by now, of course, it's been over 20 years since we've been kicking around this issue of DACA. And I know Obama didn't pass it that long ago, but Obama's program is already 12 or 13 years old by now. So even though the Republicans are really for it, it was always marked going to be a part of a deal. They were going to have more border enforcement, more border patrol agents, and in exchange for that, in this big immigration package, they were going to approve DACA. Everybody was sort of for the DACA people, but it never happened. That big immigration package, Mark, never happened. They never got any legislative relief. So what happened is the whole thing landed in the courts, with the conservatives arguing that it was beyond the power of the president. He couldn't decide not to deport 600,000 or 800,000 people. That's a legislative judgment. That's not on the edges. That's 600,000, 800,000 people by presidential fiat, basically. That was their argument. They went to the Supreme Court and it was 4-4. They didn't win. Then they went back to the Supreme Court. And by that time, the issue was if Trump had ended DACA properly. Well, of course, Trump and his minions screwed it up. They didn't do it according to the obvious way it should have been done legally. So the Supreme Court said 5-4. This needs to go back to the appellate courts. We're not going to get rid of DACA right now because Trump didn't do the proper steps to get rid of it. So by now, the case goes to this appellate court. It goes to the lower court. The lower court, this same judge who just ruled, this lower court judge says, no, this is beyond the power of the president. This is presidential fiat. It has to be done by Congress. Maybe Congress should have stepped in. The other thing I don't like about it is they didn't go by the proper administrative procedures. So the Biden administration, Alejandro Mayorkas at DHS says, well, we're going to go through the proper procedures. We're going to publish it. We're going to have a notice period. They did all of that. They applied. They went back to this judge and they said, look, we dotted our I's and crossed our T's. We didn't do anything wrong administratively. Isn't this a great program? And guess what? This Bush-appointed federal judge down there in Texas said, no, I still don't like it. But the good thing about when he said, I don't like it, are two things. Number one, he didn't enjoin it. He didn't say that they can't renew the DACA people. So they're allowed to renew. If you're a DACA recipient, definitely renew. And definitely get your DACA status going forward, which means that you can have work permits and it means that you won't get deported, okay? But you can't be a new applicant. So that part of the injunction is still in effect. If you don't have DACA status, the injunction that you cannot apply for DACA status and the government cannot give you DACA status, that remains. And so that is why the administration is upset about it. Of course, they're going to appeal it to the higher courts. People think it will go back to the U.S. Supreme Court a third time. And I guess they're probably a little pessimistic about it because if Congress doesn't step in and do something, you figure is this court any better than the 5-4 court? That 5-4 court still had Ginsburg on it.
Yeah, I mean, the prospects at the Supreme Court level are dim. And the prospects legislatively are awful because nothing gets done. That's why, even in your story, so much of it is kicked to the court.
Right.
No one wants to take responsibility. They feel it's kind of a political football ultimately. So, yeah.
Well, Tony eventually got a mere misdemeanor, no time in jail. So that particular story had a happy ending. And of course, that wouldn't have happened if Mayorkas's office, because he was still the U.S. attorney back there in 2000, the beginning of 2001, if Mayorkas hadn't done it. So I take some credit for Mayorkas getting this thing about the Dreamers. And I think ultimately these people, these Dreamers that are in the program are going to be okay. One thing that they argued to the judge, Mark, one last thing about it. One last thing they argued to the judge was, look, just get rid of one part of it, sever it out and say that maybe the people can't get work permits, but they can get deported. or maybe they can get deported. Well, I guess that would be it, that they can still get that they can no longer get work permits, but let people enter the program at least to have the DACA protection against being deported, having their life disrupted in that way. Not having a work permit is a very disruptive part of your life. If you've been working for years and you work in a hospital saving people's lives, what on earth is the public interest? But at least they said maybe sever that out. And the judge says, no, I'm not going to sever it out. And so where things stand right now, the program is not stopped for the people who are going to renew. So everyone who's listening to this, who's in anywhere near that status or knows someone who is, should definitely renew. But it does look like the effect of the order until some appellate court, like hopefully the Supreme Court. This is another one that's going to go to the 11th Circuit down there. Is the 11th, the 5th? The 5th Circuit, the circuit down there. This is the most conservative, Then is the 11th. So this is the Texas Federal Circuit, the one that we're always talking about with loose cannon down there, the one who has Trump's case.
Right.
It's made a ruling. Sure. That's the 11th. They're both very, very conservative. But until some appellate court rules otherwise, unfortunately, people cannot apply for DACA status, is my understanding. Anyone in that situation should go to a really good lawyer, because having DACA status can be very, very important, especially, God forbid, the Republicans get back into power in a year.
Wow, so much there. I had no idea that you had such personal connection to DACA and to such a high-profile DACA case. I want to quickly switch gears to two things, one of which is the Trump-chosen judge in Florida is actually being tough on Trump when it comes to the documents. She's saying you can't set up some skiff situation, security thing at Mar-a-Lago. You're going to have to go, you and your people, to establish skiff sites, and you can't have, recording devices with you, and you can't have, and everything has to be wired. She made the point that you can't, listen on headphones that are not wired. Like, she's really trying to protect what is, again, classified information, much of it, falling into categories of, super top secret. I wonder if you could speak to that quickly, because she has sort of been cutting Trump slack along the way. And as I say, she was a Trump-selected judge.
Well, yes, she was not only a Trump-selected judge, but she was sort of his favorite judge in the country. She's the one who it looked like Trump went down the road after the search occurred at Mar-a-Lago, approved by a magistrate judge who found probable cause. And he went down the road knowing that in Fort Pierce, just north of Mar-a-Lago, she was the only judge. So he truly judge shopped to go to her. And then she issued these rulings where she intervened in the middle of this case that looked like it was just between the magistrate judge and Trump and the government. So she got in that, she made it, instead of a three ring circus, she added a fourth ring, and every fourth ring that she added was, according to the 11th Circuit, way beyond the pale. So of course people had a lot of doubts about her, and we discussed the fact that the special counsel really kind of took a risk, 1 in 3, of getting her by filing in the Southern District of Florida instead of filing this case, the national security documents case, in Washington, D.C., which I believe there was plenty of venue for, and for which change of venue would never have been granted. That case would be in D.C. He took a 1 in 3 chance that it went to her, and it went to her. This particular ruling, Mark, I don't think is remarkable. In fact, I think most judges would have gone further. I think most judges would have said, you cannot have a skiff at Mar-a-Lago under any circumstances, and I'm ordering that you have to go to the skiff in such and such a place, and that's where it's going to take place, and all of those conditions that you mentioned apply. She left it vaguer than that, and I don't think most judges would have. I mean, this was very predictable. These are national security documents. The idea of him reviewing them at Mar-a-Lago, which has turned out to be porous, to say the least, and where he committed, it seems very clear to me, national security violations with these very documents. Now, you can say, well, his attorneys say he's the president. He could have seen all of these documents. To me, that misses the point. The fact that he could have seen them, 5 or 6 years ago, doesn't mean that he can refresh his recollection by seeing them again and talk to people about them. Also, if he remembers them from 6 years ago and they're highly secret, and he has never declassified them while he was in office, which is true of all of these documents that are at issue, the 30-something, he has no right to talk about them or tell other people about them. I mean, he'd be committing another violation of the Espionage Act if he were to do that. So I think she was actually pretty gentle on him under the circumstances. But I think that she is very aware of the fact that she doesn't want to be reversed by the 11th Circuit yet a third time. And so I think that she was sort of within the kind of bandwidth, the kind of normal bandwidth. But she left it up to sort of there's going to be a security officer, a court-appointed security officer who's going to decide all of this and stuff like that. And this is one that really rises to her level. I mean, once the security officer makes his or her report, she should say, look, here it is. Here's the 10 commandments set down by me, the district judge. Do this, do that, do the other thing. And yes, he's got to not bandy them about. I mean, he would be serious violation if he bandied anything about. Did I mention they're national security documents? They have to do with our nuclear secrets. They have to do with things that we've only told, like Britain, Canada, New Zealand, and Australia, our closest allies. That's what's in there.
Or anybody who went to the ballroom or went to the bathroom at Mar-a-Lago. Those, to be fair about that.
I did everything right, and they indicted me.
Hey, all right, so this is the question I have then, finally, about Hunter Biden. These charges that have just come this morning. These gun charges, because he filled out these statements not only erroneously, but falsely, I guess you would say. Could you speak to that and how he's become the poster child for sort of this GOP jihadism, but I'm wondering how it will all end up.
I think politically, it's very clear what this is. Trump is still upset, petulant about the fact that he was impeached twice and tried in the Senate twice. He wants Biden to get the same medicine because he's mad about it, and this is his rival, and they did it to me, they're going to do it to him. I also think that it's a great distraction. They hope that they can run and sort of have this whataboutism, well, they were all corrupt, and Trump did all these awful things and he's on trial. But after all, we have an impeachment trial over here in the US Senate of the other guy. So a pox on both their houses, and that will minimize how bad Trump ought to look in comparison with Biden. That's what I think it's all about. Having said all of that, I think that Biden's attorneys, and I'm sure they're very fine ones, but I think they really missed the ball on this one. I think whatever that deal was in court, they should have accepted it. I think when the judge didn't accept it, they should have gone right back and signed basically whatever the prosecutor proposed in order to avoid this. Now, what they were trying to do, Mark, was to write an agreement that was ambiguous enough or get the special counsel well, he wasn't the special counsel then. He was just the U.S. attorney for the District of Delaware, who was kept on from the Trump administration, this fellow Weiss. But I think what they wanted to do was to inject enough ambiguity or have enough ambiguity in the agreement that if Trump got back into power and made a jihad against Hunter Biden, they could say, no, this is precluded by the plea agreement. Read the plea agreement carefully. This was under investigation by Weiss. We had a pass on all of this for accepting these misdemeanor and the diversion, and now you're in breach of that plea agreement. That's what they hoped to argue. They hoped it would be ambiguous enough. The judge said, my goodness, it's a little ambiguous. So what's the deal? Is he getting immunity for anything else, or is he not getting immunity for anything else? And that's when his own lawyers said, well, oh yeah, he's getting immunity for other stuff. And Weiss's attorney said, no, he isn't. And that's when the attorney for Hunter Biden said, well, then we're out of this thing. And that's what got all the reporting. That's how it blew up in court. That was the supposed sweetheart deal that got revealed by the very, circumspect, carefully examining judge. And when that happened, they should have said, you know what? We'll take our risk with Trump in a year and a half, but take that deal and get diversion. Now, people say, Trump wouldn't have been treated like this unless he were Trump. And then other people say Trump would have been treated much better. He's been treated much better than anyone else, which is my view. And now they're starting with, well, Hunter Biden never would have charged if his name weren't Hunter Biden. And the thing that I would say to people is that Hunter Biden is not just like every other person who signed a form like that. He's a fellow who is the son of the then vice president, son of the now president, and he wrote a book about it, Mark. When do you ever have something where someone writes a book and says, during the 11 days that I was in possession of that gun, I was a drug addict? How would you ever prove that against a normal person? The proof problem is kind of overwhelming. And Hunter Biden has made the proof problem, instead of overwhelming, much easier than it would normally be for the prosecution. So having turned down the deal for pretrial diversion, What are you supposed to do at this point with the statute of limitations running? And Hunter's lawyers never would have agreed to toll the statute of limitations and have this sword over his head and say, oh, well, I think from his point of view, from the president and Hunter Biden's point of view, they could not agree to toll. That is to say, take 6 more months to think about it, Mr. Weiss. Take 6 more months to think about it. I think they had to say the statute's running. You should drop this gun charge. The average person never would have been charged with being basically an addict in possession. But again, proving someone's a felon in possession, it's one piece of paper that's certified. Proving someone is an addict in possession is incredibly hard with only an 11-day long possession of the firearm. But it looks like it could be provable here, and that's what they're going to say. For all I know, Hunter Biden will either delay this thing or he'll actually go to trial on it. He also has some legal defenses that he could put forward. He'll do that in motions ahead of a trial.
If we do see him go to trial on it, and as you just detailed it so well, and by the way, that's watershed what you said, which is, hey, I know this is an imperfect deal, essentially what you were saying, the deal that that they push back on, but it's the deal you should have pushed to make, because even though it was imperfect, it would have saved you from this, and it would have saved your dad from further embarrassment and this being a front and center issue, while there are other front and center issues that are being pushed off to the side.
Well,
what then happens?
His dad had nothing to do with this. If there
right,
was a charge that his dad had nothing to do with, he wasn't there when his son filled out that form and checked the box. No, sure. I'm not an addict.
Doesn't matter. He's got the same last name. So the deal is, David, it goes to trial. What happens? Like, what the potential penalty? Could he literally do? What's being played out in right-wing media, as you know, is he could go to jail for 10 years and he'll likely go to prison. Please give us a sense of the realities on that.
There's no mandatory minimum, so I would think that if he made a deal, which is still possible, he wouldn't go to jail at all. You have to remember, the prosecutor himself agreed that this was a no jail case. This was a diversion case. He would end up with no record. Now, having turned that down and not made a deal about it, he is going to go to trial potentially. So I think that everybody would remember that the prosecutor was willing to accept no jail time, and so I think he might go to trial. Now, the reality of our system is that people who go to trial, especially if they put on a defense that the judge doesn't believe, especially out of their own mouth, tend to get, people don't like it if you say they get punished. They don't get rewarded. The people who go to trial, especially if they think the defense is funky or the testimony, especially of the defendant at his trial, is funky, they do not get rewarded by the system, let's put it that way. So could he go to jail after trial? Yes, he could. But the trial would be, wouldn't be televised. Again, it's federal court. When this is all over, the day after Election Day, win or lose, President Biden is going to pardon his son. I hope everybody realizes that, just like Trump would have pardoned any of his kids the day after Election Day in 2020.
Yeah, great point. Great point. Kim, I think, was putting on screen the fact that it's just a weird little detail, but it's an important little detail, which is that this law that Hunter Biden is in violation of is actually a law that Joe Biden sponsored in his effort to put, some restrictions on gun ownership. And
yeah,
so
it was in the 90s or the early 90s when President Biden chaired the Senate Judiciary Committee, and he was then a senator from Delaware. He helped pass an amendment to the Gun Control Act to make sure that a gun buyer isn't an unlawful user or addicted to any controlled substance. So what's interesting is that Hunter Biden is being charged with violating part of the legislation that his father sponsored when he was a senator.
Yeah, there it is.
It's really the irony of Rudy Giuliani, the king of RICO, being charged with RICO down in Georgia.
Yes, thank you. Exactly the same kind of thing. It's true. Joe Biden can look back at the 90s and I think apologize for some stuff that happened, including Anita Hill and Clarence Thomas, et cetera. But this is yet one more thing that comes out and bites him. David,
well, it was hard to, one last thing, it was hard to do something about firearms laws. It's still hard. Senator Feinstein, she went down swinging on all those things. We had the Brady bill. Who would have thought that the Brady bill wouldn't be renewed? So they were trying very hard to do anything about firearms. And now they have the Second Amendment thing. But even before the Second Amendment, I want to remind your viewers and listeners that the Second Amendment was never a thing for over 100 years of American history. And then there was suddenly a 5-4 decision, and now everyone's running around with their Second Amendment rights. The irony would be, according to some rulings around the country, it may be that Hunter Biden had a Second Amendment right. If even an addict has a right to have a gun under certain restrictions, you see how the argument would be that that's going to be one of the motions, that he actually had a Second Amendment right to possess a gun. I don't think that's going to hold up. I think if you're a felon, you're an addict. Like I said, it's so hard to prove that you're an addict. I mean, what evidence are you going to have? Even if someone comes in and says, my ex-boyfriend used heroin every day, they're going to impeach her testimony, right? But this is a weird thing where I haven't read the book, but apparently the book is fairly explicit that he was using drugs and was an addict during the same period of time that he possessed the gun. If they had that, is the case unusual? Yes. Do they have an unusually strong piece of evidence? Yes.
Well, love you. Thank you. Really appreciate you. And you had a couple of details today that I had no idea either you would have or that you were even part of in the case of the DACA stuff. David, just such great stuff. We'll watch for you next week, and of course, and watch and listen on all of the different media outlets that you show up on.
Well, thank you.
From
Great
London
being
to the
with
U.S.
you, Mark, and you, Kim. Kim, I learned last week. Kim, I learned last week that there's going to be a legal argument. I want you on my side and not the other side.
I'll always be on your side.
Thanks for agreeing with me. In re Susanna Gibson. Thank you.
Thank you.
Kim, how are you?
Thank you, counselor.
Kim is the real deal. David Katz, everybody. Thanks, David. Hi, it's Mark, and I thought that was great. Hit the notification bell. You'll know whenever there's a new video being dropped, and please subscribe to our channel to help us save the universe.